No, that ended in high school, but it was fun while I did it.
Yeah. Okay. Well, great. All right. Good morning, everyone. It is Friday, March 12th, 9:09 a.m. We're having a little bit of a late start. Had a series of technical hiccups, but we're all here, other than Senator Westman, who's going to be joining us in progress this morning. It's a meeting of Senate Natural Resources and Energy, and we're picking up on the PUC's so-called housekeeping bill for this session, which we have drafted as a committee bill. And it is my hope that based on the feedback we've gotten from stakeholders, that there's only one small edit, and I hope that we get to sort that wrinkle out and vote the bill out of committee today in order to make crossover. Good morning, Ms. Chakowski. Sorry for the curveball with on the Zoom link. Good to see you here. So, Ms. Chakowski, I don't know if you have if you've received already the suggested change to the language, or if we should just go right to the PUC, and then Mr. Coleman, who kindly reached out to many of the distribution utilities and other stakeholders to help come up with a agreed upon edit. So, Mr. Landis Marinella, do you want to present the proposed change to what we saw the other day, please?
Sure. Yes, I'm happy to do that. And this is to section 5 of the latest draft of the bill, which deals with the change in terms of qualifying for a low-income program from 150% to 185%. And long story short, when Commissioner Cheney and I talked yesterday in the testimony about how the GMP's low-income program had at times collected more than what was needed to pay the benefits from that program, we didn't close the loop and talk about how in this last year, not surprisingly, with the COVID-19 pandemic, the opposite has been happening is our understanding, that the program's not collecting as much money as the benefits that are requested, because as you know from other bills you've seen, there are arrearages building up, and a low income program does two things. One, it provides a discounted rate, and the second is it allows for arrearage assistance for ratepayers. So the proposed change would create more of a process at the commission before the change in eligibility would occur, just to make sure we get all the relevant information at that time. I could do a screen share to show that language if that's helpful.
Sure, thank you. I don't know if you're set up yet as a co-host.
Looks like it will allow me.
Yes, he's all set.
Great, thank you.
Okay, so if everyone, can you see that now?
Yes, thank you.
Yep, and so it's just the second part that's underlined there, which allows us to set or change the eligibility level for any program created pursuant to this section only after investigation, evidence, and hearing from the distribution utility sponsor of the program and other interested stakeholders. Okay. So that's the added language. I'll stop the screen share unless anyone wants me to keep that up.
Well, thanks. Before you close it up, has everyone had a chance to read through that? Okay, great.
And we actually do currently have a proceeding open at the Public Utility Commission where we're looking at GMP's program, and we're looking at whether other utilities should have similar programs as well. And so we support this addition to the statute, and my understanding is that distribution utilities would like this as well. We received this from Mr. Coleman this morning, and the commission is agreeable to this change and think it's an improvement.
And so just to make sure I'm following completely, so at the moment, only GMP is offering this program?
That's correct.
Yeah.
Yep.
Okay. Okay, great.
And
yeah.
Sorry,
Please
just
go
on
ahead.
the electric side, just speaking of the
Right.
electric utilities. Yes.
Yeah. All right. Any committee questions for Mr. Landis Marinello? All right.
And Mr. Chair, I did have just two more quick things I wanted to mention, not on
Sure.
this section, but on the bill. I was able to talk with Commissioner Cheney this morning, and the section 4 that's in there now, as we were looking at it some more and thinking about it, where there were some changes to the Billback provision that's dealing with a clarification to Billback. And there were some changes last year that happened that, as we're looking at it more, we actually think we can take section 4 out of this bill, and that would be helpful if we could just take that out. So I apologize for that last minute change, but just wanted to request, if the committee is amenable to it, that we no longer would need that clarification.
All right. Well, let me check with the committee. I mean, this is really your housekeeping bill, so we're fine. If you no longer think you need that piece of language, then I don't see any. Senator McCormick.
Yeah. So you're saying that it's already taken care of, and that's why you don't need it?
Yeah, so this was my thanks to Ms. Sajewski for she got back to us yesterday, and there was a change that happened the last session that we hadn't incorporated yet. And when we looked at that, we actually think we don't need that clarification at this time.
Okay.
Okay. Right. So let me check in here with our council just to make sure we keep all our ducks in a row. Ms. Chakowski, do you have the new language from the PUC?
Yes, it is posted on your website today under my name.
Okay.
Also, the new language, no, I haven't seen the new language that was just discussed, but I did format into a bill the language you heard about from the last session. Okay.
So how about we pause, and so we would add the new language that the PUC just presented, and we would strike the current section 4. I think that's the total of the proposed changes. Anything else, Mr. Landis Marinello? I want to assume that we're done.
There was just one more thing I wanted to mention. This is section 6 in the language on the bill. Those are the penalty provisions. And I did just want to clarify, because we received a question about this after Commissioner Cheney's testimony. But I wanted to clarify, there's a mention there of financial benefit resulting from a violation, and we're intending that to apply to financial benefit to the violator. So it's a parallel provision to what happens for environmental violations, where there's a disgorgement of the profit. So we would be supportive of adding the phrase "to the violator" in the 5 places where financial benefit is placed there. If the committee thinks that clarification is needed, that would make it very clear that's what we're talking about. But also want to just say that on the record as well.
Sure. Yeah, clarity always seems like removing ambiguity seems like a plus in any of this kind of work. So let's check in with council and see if maybe a good thing for us to do now would be to have Ms. Chakowski put up the bill as is, and then we could walk through as a group and just see the 3 changes we're talking about.
Okay. Thank you, my dear.
Okay, so Ellen Tchaikovsky, Office of Legislative Counsel. This is Committee Bill 21-954. I'm calling it miscellaneous utility subjects. I'm not sure if that should be the precise title. And this is based on the language that the PUC sent in the other day. So this section 1 amends 10 VSA 1081. So when we're in the chapter entitled 10 on the regulation of dams. So jurisdiction of the department and the commission, unless otherwise provided, the powers and duties authorized by this chapter shall be exercised by the department, except the PUC shall exercise those powers and duties over non-federal dams and projects that relate to or are incident to the generation of electric energy for public use or as part of a public utility system. Non-federal dams at which the generation of electric energy is subject to licensing jurisdiction under the Federal Power Act shall not be under the jurisdiction of the Public Utility Commission.
And if I could just check in with Mr. Landis Marinello as we go through. So this is just stating the current legal landscape. Is that correct?
This is a clarification aimed at two particular dams where the current landscape is a little ambiguous, but there's agreement that this clarification would be helpful. We've discussed this with the Agency of Natural Resources as well. So yeah, I didn't this morning, I wasn't repeating some of the rationales that Commissioner Cheney gave yesterday in presenting these. But that's the idea for this change.
Yep, thank you.
Mr. Chairman, could I?
Yeah, Senator McCormick.
Thanks. I think this was discussed yesterday, but it wasn't clear then. What dams are we talking about? I don't need names, just the kind. They're non-federal, but they're subject to the Federal Power Act. So what kind of dam is this that we're talking about?
Sure, this is a very confusing area of the law, so that surprised you have a question, and I can name them. It's no secret this would apply to the Waterbury Dam and the Wrightsville Dam, or the two that fall into this category. And it has to do with the scope of what FERC decides to look at in its license and what it decides to not look at. And long story short, sometimes they're looking at electric energy, but not flood control. And that's created this strange situation where we end up with jurisdiction over, or could be seen as having jurisdiction over, these two dams, even though the energy part of it, which is what a public utility commission would be looking at, is actually addressed by FERC.
Okay, so the dam is not a federal dam, but the energy generation facility is regulated by the feds. That's the class that we're talking about.
It's the federal government could regulate it, which sorry to make such a lawyerly nuance, but I want to learn. Yeah, that's what's happened in these two dams, is that the federal government has basically said we could look at this, but we're leaving certain parts of the regulation to the Army Corps of Engineers. The Agency of Natural Resources is involved in those dams. And so we end up getting these questions at the commission about whether we should be looking at the public safety aspect of those dams. And for these two ones where the Corps of Engineers and the Agency of Natural Resources are already looking at those aspects, we don't really bring any added value to have them come in front of us.
Okay, so the PUC does not have jurisdiction. And FERC does not, but the Army Corps of Engineers and the State Agency of Natural Resources do. Am I right?
Yes, but FERC does as well. Kind of all three of those entities are regulating some aspect of those dams.
Okay. I'll
So
trust you.
Well, it sounds somewhat anomalous, but it's a non-federal dam. However, it's licensed under FERC for the
Yeah.
power. And then everything else that's not the power is then managed by I think you're saying, Army Corps plus ANR.
Yes. And so when those proceedings have come to us, we basically just said, do what the Army Corps of Engineers and ANR tells you to. And there's not really much added value to doing that. So this cleanup seemed to make sense.
Okay.
Okay.
What does make it a little confusing is it's a non-federal dam, but it's subject to FERC. So
This is
I
why
agree.
people hate us.
Yeah. And part of that, this is just showing the changes. There are also, if you looked at the full statute, there's language defining non-federal dams. And so that's why this changes using that same term.
Right. Thank you for the disambiguation.
Yeah.
All right, section 2 is on page 2. 10 VSA section 1100 is amended to read federal cooperation. This is also related to dams. So this is repealing all of subsection 1 under this language. So as a basis for cooperation with the federal government and its duly established agencies in the matter of flood control, the state defines its policy with reference to flood control development as follows. And so it's striking this language here.
And that's part of the same change. This is just for consistency.
Thank you.
Okay, section 3. So now we're in Title 30. Section 3, Public Utility Commission. The Public Utility Commission shall consist of a chair and 2 members, and each member shall not be required to be admitted to the practice of law in the state. And then this goes on to list some of the other features of the Public Utility Commission. But this is adding new language. So the clerk may appoint and assign a former commission member to sit on specific commission cases when some or all of the regular members are disqualified or unable to serve. In making assignments, the clerk shall begin with the former commissioner who left service most recently, and then as needed, continue to proceed to the next most recently serving former commissioner. Former commissioners shall receive pay in accordance with subsection E of this section. So this is sort of about what happens when there's a conflict, and the commission is a pretty small body, so I don't think there are existing alternate provisions.
Okay. Thank you.
Section 4 is the Billback language in Title 30. And the commission has suggested this be struck, and I agree. I think it's pretty well covered already.
Okay. Any committee questions before we leave that one? All right. Thank you.
Section 5. So now we're in the penalties section in section 30, in Title 30. So so the change doesn't happen until page 5. So if the commission determines that the violation did not cause or is not likely to cause harm, the commission may impose a civil penalty of not more than $42,500 in addition to any financial benefit resulting from the violation. And so I do think this is where the PUC was just suggesting clarification language, and I do think it could be even more clear potentially, but but I do think clarification language here would be helpful.
Okay, so it would be the insertion of the phrase "to the violator" after the phrase "financial benefit." Right.
Yes.
makes sense. If you made money over breaking the law, that's the problem. Okay. And Mr. Landis Marinello, you said there's 5 instances of that in this section. Okay.
Yes, I think we can see 3 of them on the screen. And if you scroll down, that the phrase financial benefit appears a 4th time there at the bottom, and then one more a little further down.
Okay. Any committee discussion on that one before we continue? Okay, not seeing any.
And
Yeah.
so these, you haven't taken any testimony on this, but I haven't looked to see what comparable penalties are, but these are all pretty large raises. You're raising 10,000 to 42,500, 40,000 to 85,000, and then 100,000 to 170,000. So I don't have any information on how those numbers were set, but
I think we heard that, but Mr. Landis Marinello, can you refresh the committee's memory how the adjustments were made, please?
Yes, so we looked to Title 10, and it's specifically chapters 201 and 211 of Title 10, which is for environmental violations. And as the committee is aware, for electric generation projects, for instance, we're the permitting authority rather than Act 250, but we could have projects that are comparable to Act 250 projects. And so it didn't seem to make sense to have lower financial penalties in our permitting regime than what there is in Act 250 and for other environmental violations. And these penalty amounts can also come up with service quality investigations and things like that. And the numbers that were in there were set, I believe, 25 years ago and have never been adjusted upwards, both to keep up with inflation and also just to keep up with where penalties have gone for other environmental violations.
Okay, thank you.
okay, so then in section 6, we're now in section 218, so jurisdiction over charges and rates. And you've already heard about this section. This is where the low income electric utility customer definition is that the PUC has suggested amending.
And Mr. Landis Marinello, could you send that language directly to Ellen, please? Ms. Jakowski, please.
Yes, definitely I'll do that.
Thank you.
Okay, section 7 amends section 248. So let's see. Any party seeking to proceed under procedures authorized by this subsection shall file a proposed certificate of public good and proposed findings of fact with its petition within 2 business days of notification by the commission that the filing is complete. The party shall serve copies of the complete filing on the parties specified above in the statute. And the party shall give written notice of the proposed certificate and of the commission's determination that the filing is complete to those parties. So this is shifting the burden of providing notice from the commission to the party. And I think we are in the part of section 248 related to limited size and scope projects. So just a subset of the projects under section 248.
Okay, thank you.
And then on page 8, so language is struck here that requires the commission to publish the notice on the commission's website.
Yeah,
about whether the filing is complete.
and I'll clarify, all the information is going to be publicly available through EPUC, our filing system. This is just cleaning up the fact that these smaller projects we would have to publish on the website, and it could be confusing to the public because we don't have a comparable process for much larger projects that are proposed.
Okay. Thank you.
Okay. Section 8 is section 249. So the commission shall have power to exercise the jurisdiction conferred by this section only after due notice to all interested parties and an opportunity for hearing, and after making findings that the service territories established or altered are consistent with the general good of Vermont. If a hearing is requested by a party or by any customer who is potentially affected by the proposed change, the commission shall hold a hearing.
Okay. So my recollection is there are instances where it's non-controversial, and this makes the hearing optional in case that either the commission or an outside party decides that a hearing is merited, but otherwise it can go forward without a hearing.
Exactly.
Is that correct? Okay, great. All right.
And finally, section 9, section 8005A, we're in the standard offer program. So at the request of a plant owner or for good cause, the commission may extend a period described in subdivision 1 of this subsection J. If it finds that the plant owner has proceeded diligently and is in good faith, and the commissioning of the plant has been delayed because of litigation or appeal, or because the need to obtain approval, the timing of which is outside the commission's control, or for other good cause as determined by the commission.
Right, and I think the explanation for this one was, for instance, right now we've had a pandemic, and that was a good cause for altering the schedules. But you had no basis for offering such an extension.
The statute didn't clearly state here's a way an extension like that can be offered, and so this would make clear we have that authority.
Great. Okay. Thank you, Ms. Chakowski. So committee, just keeping track of the pieces here. Is the committee amenable to making the 3 sets of edits? One was the section the PUC wishes to withdraw would be withdrawn. The new language relating to the 185% versus 150% would be inserted, and then 5 instances of the phrase in the subsequent section will be inserted. Ms. Chakowski.
I also need to know what you want the name of this bill to be.
Okay. I think we started with something very generic, right? The miscellaneous utility.
Right, so that's what I have it as currently. Miscellaneous utility subjects. Is that adequately describing your intent?
Seemed it to me, I mean, it's not going to be a page turner, but it's just describes what we have. Collection of edits really to existing law. Everyone fine with that? Right. Okay, so thank you. So we have those 4 things nailed down. Ms. Chakowski, will you have the opportunity to make those changes and return to committee today?
Return when?
Well, we don't have anything going. We had a cancellation or whatever right after this, we're going to be reconvening at 10:45 to look at S102. So we could tack this on to the other end of that, like 11:15-ish.
No, I can come back shortly. I am
Okay.
double booked for the rest of the day.
Okay.
So I think I can make these in the next 20 minutes. Can I come back around 10?
Sure.
Okay.
We'll do that. Okay. Thanks for your flexibility. I know it's the
It's
witching
crossover.
hour. Yeah, well, witching hour 1 is ending and witching hour 2 is about to begin, but whatever, we're getting there. Okay.
Before we wrap up,
Yes.
Joe, and I'm sorry. In my defense, I'm going to point out I'm newly returned to this committee. I'm not entirely clear on what we're doing with the dams. Does that exemption from the PUC, would that cover the Marshfield Dam, for example?
No, we would still have jurisdiction over, it's about 20 dams that we would still be looking at. So it's not altering that.
And nothing is being left unguarded.
Correct. Yes.
Okay.
That we looked at that very closely. We spoke with the Agency of Natural Resources with their technical expert on dam safety regulation, with some of their policy folks and their general counsel, to make sure that we weren't going to leave any sort of gap. And I think it will actually make it easier for the entities who are currently regulating those 2 dams to do what they need to do to protect the safety of everyone at those locations. And it just cuts out what had been potentially a meaningless process of coming in front of us, just to have us tell them to make sure they complied with what those other entities directed them to do.
Okay. Thanks.
Thank you, Senator McCormick. It's always good to make sure we know what we're talking about. Appreciate that.
Oh, that. Or at least look as though you do.
And before we recessed, Mr. Coleman just wanted to check in and say thank you for your outreach, circulating this draft to the distribution utilities stakeholders. Do you have anything to add? It's my understanding that this language that we were talking about has been agreed upon by folks outside the PUC who are regulated.
Sure, this is Warren Coleman. Yes, you're right, Senator Bray. I took the opportunity to circulate it to the distribution utilities as well as Velco. And we are fine with and support the language that the PUC has put forward, and appreciate the amendment there on section 5. So I think we're all set. I checked in with VEC, GMP, VEPSA, WEC, Vermont Gas, and Velco.
Great. Thank you for that. All right. So with that, let's recess till 10 o'clock, at which point we'll have a revised bill and we'll be able to vote